cheesy as ABC. Simple as 1, 2, 3. Get down with UGK. Pipsy B, you with B. Cause what's a hoe with no pimp? And what's a pimp with no hoe? Don't be a lame, you know the game and how it goes. We try to get toes.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine poisoning.
Testing 1, 2, 3, 4, 5. There we go. All right. I thought it was working. What? Why is my what? Why is my voice changer? What? What the hell's happening here? One, 2, 3, 4, 5. Yeah, I know this is not the right one. Don't worry. Mm. Mm. Oh, hello. 1, 2, 3, 4, 5. Is it? Are we good? We back? Oh, thank you. Hello. I don't know what the heck happened there, but hi. It is Artie of Artie's Corporate Fiction. Hope you guys have been doing well. Um, we have an educational stream today. I think the problem is that I think OBS is being a jerk. And that's the big problem. Anyway, we're gonna listen to Eddie Craig's Right to Travel script and learn a little bit more about Eddie Craig himself. And then we're also going to go finally listen on the talking frog. I feel like I've talked about the frog so many times, but many people haven't really don't even know what I'm talking about when I mention the frog. So we're gonna go through both of that today. Um, the big issue here is that Eddie Craig claims to be a former Texas sheriff. Now, I haven't been able to fully confirm this, but I'm about 85% to 90% sure that he was never in law enforcement. At best, someone I don't someone has told me that at best he was a part-time jailer, a part-time corrections officer that lasted for only a couple weeks. But he since claimed to be a former Texas deputy sheriff. Uh, what what the hell happened to my audio? Because now I see that you guys can't even hear it. Oh, there we go.
Public building stops, so
There
on
we
and
go.
so forth. It would surprise you to a great degree just how much the American people are no longer in touch with what their basic, common, unalienable rights actually are. We've been indoctrinated into surrendering them to the state and to those that we judge to be in authority over us for far too long. It's probably one of the biggest reasons for government-controlled schools is simply because this indoctrination process has to be done slowly, because what they're telling us about what we have as far as rights are concerned and how they actually treat us in regard to those rights are very much in contrast and in contradiction to each other. But by doing it slowly over time, the way they're doing it, most people have gotten to the point where they don't even notice any longer that they have been deprived of those rights until it's far too
Yes, InfoWars gave this guy a platform.
late. This is the transportation script that I wrote and am currently recommending for use whenever you're engaged in any type of public interaction, most appropriately a transportation stop, but it can be used in any situation where you're having to deal with any type of public servant who is attempting to exert some sort of authority over you or your property or something of that nature. So that being said, there's a couple of general rules when it comes to.
And also, for the record, this video was uploaded 10 years ago, and I think the actual recording of this is even older. This is way well before the current InfoWars mess that's been happening in the last couple of years.
Dealing with public officials. One of the things I've got here on the transportation script is it's best for you to memorize as much of the actual questions portion as possible.
Vintage.
The instruction portion, don't have to worry about memorizing. You just need to know the basic premise of why the instructions are what they are so that you can apply them properly to the questions and the context in which you're having to use them. That being said, one of the major rules I stress vehemently to the people in my class is you're no longer in the world of rights and safety. You're in a world of government intolerance of the very people that empower and create it. The government wants you to be its subject, not the other way around. So, never leave home ever again without some form of recording device with you. Doesn't matter if it's your cell phone, doesn't matter if it's a voice recorder, doesn't matter if it's multiple of either. Don't leave home without something that records. Anytime you find yourself in a situation where you.
So far, this isn't exactly, terrible advice. You do want to have your own record if you're being stopped by the police, but I don't necessarily disagree that you would want to have your own recording of the encounter. So I'm not really. Yeah.
You are about to have to deal with a public servant. I don't care if it's someone you've known for years, but you are going to see them in their official capacity as whatever they are, a court clerk, court of record clerk, the county clerk, whatever. You record that encounter. You never know.
Now, I don't know about that part, but
what your public servants are going to attempt to do at any given time anymore. Police officers are being trained to treat us as the enemy. They are first and foremost the ones you have to watch out for. Never talk with a peace officer, police officer, or any other type of officer if you're not recording the encounter. All right, now in the transportation script, you'll notice the yellow highlighted area at the top, the do's and don'ts. These are very important things you need to know. You don't have to memorize these, you just have to know why they exist and what they are for. The first one is, do remember that an officer is required to read you your rights before questioning or searching you if they have placed you in a custodial arrest.
okay, so here's where we're going to start to diverge. The first half of his sentence is correct. If they're before a police officer is about to, well, I don't know about the searching, but before they're about to question you or engage in a questioning, the officer is required to give you a Miranda, read you your Miranda rights. They are not required to give them to you automatically at the moment that you are under arrest. No, they're not required to do that.
Now, one of the things that most people in Texas do not know is that every time you are stopped for an alleged transportation stop, you are already in a custodial arrest. There are many sections of Texas law that make that clear, but the one that will make it the most pointed will be Chapter 543 of the Transportation Code, where it talks specifically about the arresting officer may release the person arrested.
So I do not know if this is true. In Texas, now I did learn that in Texas you do have to have probable cause over not just RAS, and you need probable cause to arrest. And under Texas Code 543, Transportation 543, any traffic violation within the Texas Transportation Code is an arrestable offense. But I don't know. I'm not sure if it's true that at the moment of stop, you're under arrest. You're explicitly under arrest. But either way, regardless of whether you are or aren't, what he's going to say is BS, in that he's going to say that the moment an officer stops and the moment the officer goes up to your window, he's required to give you your Miranda rights. That's false.
From custody and so on and so forth. You also have a Texas court case that says very clearly that that arrest that occurs in 543 is a custodial arrest. So
it doesn't give you the court case, of course.
They will always tell you, however, that you're not under arrest. They will tell you that you're in a custodial detention. This is a lie. The reason they're doing this is to get you to start talking freely. Because under arrest, you're liable to watch what you say. Under arrest, they have to read you your rights, which is what this is dealing with. If they don't tell you that and you just talk freely, then anything you say can and will be used against you, and you can't get it suppressed later because the court will view it as a voluntary.
Also, yes, Jassa also makes a good point. Even if this is true, and that there is a court case supporting him, this only applies to Texas. This doesn't apply to any other state.
Statement. So you need to know immediately that the moment the lights come on in Texas relating to any form of traffic stop, you are already in a custodial arrest, and you need to act accordingly. That being said, when you look at this and you read 543.001 through 009 of the Texas Transportation Code, you will see that that's the case. You'll also see that the reading of your rights is a mandatory requirement that works in your favor.
It does not say this at all anywhere. Hold on, let me put it. Here's a Texas Code 543. Apparently, it hasn't actually changed in a long time. I see nothing. I see arrest without warrant authorized. Any peace officer may arrest without warrant a person found committing a violation of the subtitle. Well, I just said it earlier. Any traffic violation or traffic violation is an arrestable offense in Texas. In Texas, not every state, but in Texas. Now, it also says that the person must be taken before a magistrate. If they decide not to sign the citation. Yeah, see, 543.002A2. A person arrested for a violation of the subtitle is punishable as a misdemeanor shall be immediately taken before a magistrate if the person demands an immediate appearance before magistrate or refuses to make a written promise to appear in court as provided by this subchapter.
Unless you're dumb enough to continue to talk.
It says nothing again and again. It says nothing in he said 543.001 to 543.009. None of these provisions say anything about an officer's obligation to Mirandize you at the initial point of a stop anywhere.
Talk after you've been so informed of this. And you can see that under Article 38.22 of the Texas Code of Criminal Procedure. Be aware, however, that the cops almost never read you your rights. Never.
Article 38.22 does not say that either. Texas Criminal Code 38.22. Sorry. I'm enjoying Thin Mints. This is only about evidence in criminal cases. And that potentially evidence can be suppressed if, somebody was not Mirandized before providing potentially incriminating statements. But that's a separate issue. That says nothing about, again, it says nothing about an officer's obligation to Mirandize somebody at the point of stop.
Not when they arrest you, not when they search your car, not when they do any of that. And
he's incorrect. He's dead wrong.
They're
here.
required to do it.
No.
So these are the things you need to be aware of. That means anything you say that can be incriminating, like using the 7 deadly sins, or agreeing with the officer that you were driving, or that this is a vehicle, anything you say or do in that regard is a nail in your coffin at trial.
Oh my God.
Because you're basically...
It doesn't matter whether you describe your conveyance as a vehicle or automobile or car or method of transportation. Doesn't matter.
Basically admitting that what he's accusing you of, the regulable activity of transportation, is actually applicable to what you're doing to your car and to your actions and to you personally, when in fact it isn't. But because you're so used to these terms that they're using, you simply agree with them. That's your first mistake. So one of my major rules is there's 3 parts to this. You shut up, you keep shutting up, and when you've done that, you shut up some more. Now we'll get to...
This advice is perfectly fine, by the way. There's nothing necessarily wrong with saying, do not answer the cops' questions. However, you still have to provide the big 3. License, registration, insurance. Or if you don't have a license, your name and date of birth. That's it. Those are your obligations. Beyond that, you don't have to answer any question. If a cop asks you, hey, where are you going? You don't have to answer that. Where are you coming from? Don't have to answer that. Have you had anything to drink tonight? Don't have to answer that. You don't have to answer any of those questions. However, you are still obligated to provide the big 3. Akira, thank you for the $4.99 super chat. Appreciate it.
To that in the do's and don'ts in the next one here. Right now, let's finish this up. Oh, keep it back up, please. Okay. Since they never read you your rights and you are in a custodial arrest and the officer is lying to you about the custodial arrest, you need to make sure you know that, okay? You are always in a full-blown custodial arrest. Okay, now pop that other one up.
Again, I don't know if that's
right.
actually accurate. I don't know.
Don't ever answer an officer's questions. There's no requirement for you to answer their questions. I don't care what they tell you. There's no requirement for you to give them anything that they want. Yes, Texas law says you have to give them a license, you have to give them registration, you have to give them proof of insurance. Problem, that's a due process violation. The law is attempting to...
So his entire reason, his entire response to the requirements that we talk about is just, well, it's unconstitutional, bro. They can't do it. Oh, well, me.
Make it mandatory that you waive a protected right in order to exercise some alleged privilege or exercise an actual right of another type. And it can't do that. No law can do that.
Then why have all of these laws stood up for the past, like, 80 years or so?
That law's invalid on its face the moment it attempts to do that.
Oh, yeah? Challenge it. How many people have challenged it? Lots. How many people have won? None.
So you have the right to remain silent. Use it. However, remaining silent does not mean become a deaf mute. You still need to talk and you still need to respond in certain ways. It's just not going to be in a way that implicates you or provides them with evidence or information they can use against you. That's what be silent means. Not stop everything. It simply means don't be saying and doing anything that helps them and hurts you. That is the reason why I have a major three-part rule about everything here. That is everything that comes out of your mouth has to be directed to one of three specific purposes.
Oh, boy.
Invoking a right, demanding a right, or protecting a right. If anything you're saying or doing isn't intended to do one of those three things, then you're doing the wrong thing. That being said, it simply means, again, to not be a deaf mute, that you are not to provide any information or documents in response to the officer's demands or questions. That means you don't give him a license. You don't give him registration. You don't give him proof of insurance or anything else.
So if you guys want to know, Eddie Craig is probably responsible for so many window busts you wouldn't believe. This one guy.
All of these will be considered at trial to be a waiver of your protected right to remain silent. It will be considered a waiver of the requirement that they Mirandize you before they seize evidence and statements that they can use against you. And believe me, folks, all of this information can be used against you. It can also be used to further incriminate you. An example being, let's say your birthday was yesterday, and you have a license that you give the officer that says your birthday was yesterday. Can the officer under Texas law charge you for driving without a proper license? Absolutely.
Okay, he forgot to mention that, let's say that you have a license and the license expired yesterday because the expiration date was your birthday.
It expired yesterday on your birthday. So unbeknownst to you, you provided him with something that he can actually charge you further.
But you are still required to provide it. Again, he basically hand waves the Texas law in place, requiring your license, registration, and proof of insurance. He just hand waves it, and every idiot who listens to this and follows the advice, they also hand wave it or ignore that part completely. That you could be arrested for not providing that information.
They're with.
Because again, remember, as what he mentioned, and what Texas law states, Texas law, any type of violation of the Texas Transportation Code is an arrestable offense.
And he's got
one of those things is failing to produce your ID.
The actual evidence because you gave it to him. If he demands that, or the prosecutor demands you produce your license at trial, so he can show that it was expired on the date the citation was issued, what are you going to do? You're going to have to produce it. You can't have it suppressed because you voluntarily gave it to the officer at the time. You waived your right to remain silent by giving it to him. Same thing goes if you have the wrong or an expired insurance card. Same thing applies with registration, any of it. They can't compel you to waive your right to remain silent and not to self-incriminate in order to meet their requirement of tell me that you have what I want. Because what they want is for you to allow them to get you in that vice of pay us money or we'll come after you for more money. That's what they're after. So, again, the three fundamentals. Any information or documents in response to the officer's demands or questions is going to hurt you. Invoke your fundamentally protected right to remain silent and to assistance of counsel, and then simply refuse to waive those rights. How do we do that? Well, you waive.
Again, I'm not disputing that to keep yourself silent. You still have to provide that info, though.
It because you complied with the officer's demands. The moment you comply, it's waived. You're done. It's over. You cannot get that back. You cannot ask the information be suppressed because the courts will say you gave it up voluntarily. The foremost thing to remember in these situations is to not engage the officers in idle conversation, dialogue, or chit-chat. Why? Because the more comfortable you are and the more talkative you become, the more likely you are to say or do something that's going to hurt you somewhere down the line, or that will give this officer more information he needs to conduct what he's going to refer to as articulable probable cause or a heightened reasonable suspicion to say that you were doing something more illegal or that would give him an opportunity to go fishing down a different path. So don't just talk. Again, if you're doing that, you're doing it wrong. Now, this is known as my self-imposed rule of invoke, demand, and protect. Once you've invoked these rights, you never waive or abandon them by ignoring the procedures I'm giving you here. Any question the officer asks, like where are you coming from, where are you going, who are you meeting, they have nothing to do with the stop. Stop answering those questions.
Again, he's not wrong here. I'm not disputing this part.
It's none of his business. He has no right or authority to know that. The only way he's going to get those answers is because you give them to him. And he has no business knowing. Stop giving your whole life up to these people just because they tell you they want it. They are used to simply getting these are used to get additional information that may allow the officer to continue his witch hunt and escalate the severity of the charges he might make against you. Also, never answer questions like, do you know why I pulled you over? Or are you aware that you...
Again, you do not have to answer those questions. And I agree with you that the cop asking, do you know why I pulled you over? Are you aware that blah, 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 blah? Those are, those questions are designed to incriminate you. So no, don't answer those questions. Again, I'm not disputing any of this. It's just, you still got to provide your license, registration, insurance.
Stop helping this guy screw you over. That's what he's doing. When he asks those types of questions and you answer, what are you doing? You're giving him evidence. Well, yeah, I guess you caught me speeding back there or running that stop sign or going through that red light. Thank you for the confession that he has on his audio-video recording and will use against you in a court of law. Stop answering questions. Just don't. Next slide, please. You do need to remember to do the following immediately when you realize you're getting pulled over. First and foremost, roll up all of your windows and lock all of your doors. Okay, why? Because these guys are getting more aggressive every day about jumping in your car without any probable cause, coming in from the passenger side, your side, and just pulling you out of the car for no good reason, yanking your keys out of the ignition and refusing to give them back, any of those things. Roll your windows all the way up, lock all of your doors. That keeps them outside and you inside until they can give a viable reason why that needs to change. Don't give them the opportunity to do that. My personal habit, I'm not going to get into my habit because I don't recommend most people do it. You get the document by going to the website and downloading it. You can read what my habit is, but I'm not going to talk about it here. Do remember, however, that my objective here is not to get anyone hurt or injured. You have to use your own judgment as to how far you're willing to press your rights and keep them. That's entirely an individual requirement. You and only you know the situation you're in at the time. You and only you have reason to believe this officer is going to lose control and do something that will seriously injure you. You need to take that into consideration whatever happens, okay? But that being said, you need to be very careful that it gets to a point that is documented that you did not waive that right willingly, that you were forced to do it. Don't ever roll down more than one window at a time if you do remain in your car when you get stopped. No matter what the officer tells you to do, one window only. I don't care if there's cops at every window saying roll this down, don't do it. One window only. Why? Well, if you create more than one air vent in that car by rolling down multiple windows, you will create a cross breeze inside of that car. If you do that, that immediately gives the officer the opportunity to say he smells something coming from the car.
I'm calling bullshit on this. I have never heard of this idea that a cop needs two windows down in order to be able to smell weed, or somebody who smells like they've been on a bender. I've never heard of this. I mean, has he never heard of like hotboxing? Do you think like if somebody's hotboxing in a car and the guy rolls down one window, you think the cop's not going to be able to smell anything from that?
With a single window down, that is impossible. Nothing can exit the car in that manner. There's no wind to blow it out the window for this officer to allegedly smell. So don't ever do that, because the first thing he's going to do when he can't get what he wants one way is he's going to attempt to escalate the stop and get it another. Don't ever roll your one open window down more than 2 and 2.5 inches. Again, no matter what the officer tells you. If he tells you...
Well, now you know where people got this whole idea of rolling down the window 2 inches. This guy.
You have to roll your window all the way down. Just sit there and say, officer, I like the window where it is. I can hear you just fine. I'm comfortable with it right here. I don't want to roll it all the way down. I'm not going to roll it all the way down. There's no law that requires you to do that. Now, be aware that he will get upset by this, and he will attempt to threaten you, but he's not at a point yet where he can actually justify anything he does that consists of violence. He can yell, scream, and holler at you all day long, but he can't start trying to break your window or anything because you won't roll it all the way down. So just keep...
Well, it depends on where we are in the situation. If the cop has been asking you over and over and over again for your license, registration, and insurance, and you providing nothing, including any sort of name or other form of identity, then they can possibly escalate it to where they're going to demand you that you get out of the vehicle, which they're allowed to do under Pen v. MIMS, or they could potentially break the window and force you out if you're not going to identify yourself in any way, shape, or form.
Keep that in mind and keep going. Now, when we go forward on this and we look at the next do's and don'ts, don't ever provide an officer with any documents or other information that they demand. The legal ramifications to your fundamentally protected rights are devastating. Again, everything you give out voluntarily will be considered exactly that, voluntarily. It can be used against you, and there will be no chance of you to have it suppressed because you waived the right to remain silent and not provide that information. Don't ever give your consent to an officer to search your car for any reason. That's just dumb. Don't do it.
I also
Without
agree.
a warrant, they don't have a reason to search your car unless they actually put you in the back of theirs with the intent of taking you to a magistrate, which is where there's...
No. Depending on what the cop can see, if there's something in, this is where plain view comes in. If they see an open container or if they see a baggie like laying on the passenger side, then they have probable cause to search your vehicle.
They're supposed to take you, even though they take you directly to jail. You need to be aware that that also is illegal in most states, including Texas, and that you can sue them.
Okay, so it took me a little while to look this up, but from what I saw, what I was able to locate is that you are in Texas. You are entitled to see a magistrate within 24 hours if it's a misdemeanor, and within 48 hours if it's a felony charge. That's in Texas. So no, they don't have to take you immediately from the backseat of a car to a magistrate. They could put you in lockup for a couple hours or up to 24 hours if it's, again, assuming it's a misdemeanor, before you see the magistrate.
Them for false imprisonment when they do that, but that's beyond the scope of this presentation. If you want to know more about that, come to my classes down at Brave New Books, or join Tao of Law when it launches.
Of course, these sell seminars, sell courses, as these guys are wont to do,
and you'll get to learn about it online. Now, if you give them consent, here's the potential downside. You are asking for the incriminating evidence to get planted in your car, or evidence that you may not have even known was in your car to be discovered. You could have had a friend in there that got nervous and had a joint in his backpack or his pocket or whatever, and immediately threw it under the front seat when the cop pulled you over. You could have got stopped yesterday by another cop, and you had someone with you that did something similar. And now today you get stopped again and thinking, well, I'm alone, there's nothing in the car, I don't have anything, so yeah, go ahead and search. And you got a joint laying on your front seat that your friend threw there and you knew nothing about. Don't consent to a search that doesn't have a warrant attached to it. Just don't.
They don't need a warrant.
This is the key reason you don't get out of your car.
They don't need a warrant. They need probable cause.
Because they have to have a really good reason, such as actually saying, we're taking you with us, in order to get into that car to perform a search without that warrant. The search incident to arrest requirement that allows them to do it without a warrant, even though you're in a custodial arrest, they're lying to you about that and haven't informed you of that. So if they attempt to search the car at this point, the search can get thrown out and suppressed as being illegal.
Oh
and
my
they know
God.
it.
No,
so
no, that's
don't
not right
ever
at all.
give consent to search.
Oh my God.
Okay, next one. All right, the officer is going to almost always insist you are not under custodial arrest, but rather are simply being detained or a part of an investigative detention. Again, that's a lie. No officer has the authority to simply walk up and demand that you answer questions, produce ID, or provide them with your private information, but they're going to try to do that, okay? So it doesn't matter whether they're doing it verbally, doesn't matter whether they're demanding you give it to them in the physical form on an ID. They can't just walk up and demand it, and you're not required to give it to them.
Detainment is not an arrest. Again, an officer only needs to have reasonable suspicion to detain you. Now, depending on what state you're in, again, I don't think, and Texas is not a stop and ID state, you may be required to provide your information at the point of detainment. In Texas, you need to be, I think in Texas, you need to be placed under arrest before you're required to provide your ID. Yes, Texas is not a stop and ID state. So, no, he's absolutely incorrect. He could detain you and ask you questions. You don't have to necessarily answer those questions. But no, detainment, yeah.
Be aware that when you won't submit and give them your information, though, their favorite tactic is to start threatening you, and they're going to start trying to say they're going to charge.
Well, again, yes, I'm talking in context outside of a traffic stop.
Charge you with failure to identify, which here in Texas is one of their favorites. But the problem is, when you read the failure to identify statute, there's only specific ways to commit that offense. And in either case, in order to charge you for not providing information, the officer is required to have already arrested you for some other type of offense. Failure to identify is not...
But you just said before And if you're stopped by the cop, you're under custodial arrest for something. The cop didn't stop you for failing to provide ID when he put his lights on and stopped you. But you admitted that the moment he stopped you, you're under arrest. So if you fail to provide your ID, he's not even under his own logic. He's wrong. Oh my God.
An arrestable offense in and of itself, except into subpart B, where it gives the requirement that you don't provide false information in a legal detention. But notice the contrast. In a legal detention, you can't give false information, but you can refuse to give any. Whereas in a lawful arrest for some other offense, you shouldn't give false information and don't, but they also, at that point, they say you can't refuse to give them name, address, and date of birth. And that is the only 3 pieces of information you're required to give. But nowhere are you required to provide that information at any time on a physical form of ID. You don't have to do it with a license. You don't have to do it with a passport.
Unless you've been stopped in a traffic stop.
You don't have to do it with any form of physical identity.
Failure to provide your ID is a separate offense to failure to present your license is a separate offense from failing to identify yourself. Those are 2 separate offenses. And he's conflating them both. Akira, thank you for the $4.99.
Identification. Verbal is enough, as long as you provide those 3 pieces of information if you've been lawfully arrested or detained. Now, given that, when you go down a little further on that, and you be aware that you don't give them the information, they're going to try to charge you with failure to ID, or they're going to attempt to charge you under, after these following conditions, as I just stated, under the arrest versus the detention. They may try to charge you with obstructing governmental operation as well. Again, you cannot obstruct governmental operation simply by refusing to say anything, nor can you do it by verbally responding or interfering with what they're doing by not being quiet. It has to be some sort of physical interference before.
I haven't been able to look this up in Texas. I think he's absolutely wrong when it comes to Texas. Some states do require an obstruction charge to have some sort of physical element to it. But no, you could be charged with obstruction potentially based on verbal conduct, on verbal actions.
You can be charged with that obstruction of governmental operation that they try to use. But they will do anything they can to intimidate you if you let them. You need to maintain a calm, cool, self-composed posture at all times. You want the video evidence to show you never lost self-control. If anyone lost control, it was the officer or officers on the scene. They got upset. They lost their temper. They made threats. They assaulted you or your car, okay? That's what you want the evidence to show. When you start standing up for your rights, I guarantee you these guys are going to start being upset. But when we get to the questions, you're going to see exactly why that's important. Now, when you go down, don't need to give them physical ID. You just simply need to verbally give them those 3 pieces of information. All right?
Again, but you may get a separate charge for failure to possess a driver's license.
Let's go to the next.
Which would usually be dismissed when you go to court and say, hey, I did have a license at the time. I did have a valid license at the time of the stop, and that's going to be dismissed if you show that to the judge.
Now, how do you know when you are in custody and are required to provide these 3 pieces of information? How do you know when you are in custody where the officer is required to read you your rights?
Oh, boy.
Well, this legal equation, as I call it, was taken directly from the case law dealing with that particular aspect of the term.
Again, he doesn't cite it.
Custody and functional equivalent of custody. Custody is custodial arrest or functional equivalent of a custodial arrest. And like I said, here in Texas, 543 of the Transportation Code tells you you're in a custodial arrest by law right off the bat. A functional equivalent of custodial arrest is when a reasonable person, considering the totality of the circumstances, would believe that he or she is in police custody to a degree associated with a formal arrest. In other words, you can't say, am I free to go? And the officer turn around and say, yes.
No! If you're detained, you're not free to go either. So then what's the difference with... what's the difference between detainment and arrest at that point?
If you say, am I free to go, and the officer says no, now you have the legal presumption of custodial arrest.
No!
That becomes very important with that 38.22 of the Code of Criminal Procedure when they must inform you of your Miranda rights before they proceed.
Kill me.
Next. Okay. Now, everything you do is directed at protecting yourself. Everything. And you need to remember these two important factors about any traffic stop. The purpose and intent of every transportation stop is to escalate it to either a DUI or drug bust. Always. That is where the officer will attempt to escalate.
No, he's not.
The stop to if given the opportunity. That's just another reason why you do not answer his questions. You do not get into chit-chat or idle talk with the officer that will give him any reason to latch on to any statement that you make and allow him to escalate it to one of these two much higher and much more dangerous offenses. So do not do any of those things. This is what they're going to attempt to do. Be aware of it, expect it, prevent it. Do not attempt to educate the officer. Don't tell him what his job is. Don't tell him who you are. Don't tell him, you know, this is what the law says you have to do. I know my rights and blah, blah, blah. You're attempting to educate an officer on the side of the road. Unfortunately, most of these guys, besides not caring, don't have the IQ for it. Now, that's not to say there's not good officers. There are. I fully agree that there are. But the good ones are too few and far between to stand up by themselves to resist the bad ones. They need our help. Once they see they're not outnumbered, maybe they'll get a voice. Maybe they'll get in a group and make a voice. I don't know. But the only way to do it is to know this for yourself at the moment, so let's get with it. Once you know the officer's name and his badge number, you're going to use that as often as possible while you're going down the things in this script. Why? Because you want that officer associated with every illegal activity you can get him into while he's got you. So you want to directly relate him and what he's doing to some violation of your rights at every single opportunity. That also makes any video record self-authenticating. When everyone that's in the recording is known, no one has to testify as to, well, this is that person, this is that person, this was made here, this was made there. It becomes self-documenting and self-authenticating.
No, you can. I mean, it's easy to do, but you still can lay a foundation to authenticate it.
When everybody's name is stated for the record, when everything in it is agreed that, yeah, that's what was said, that's who it was, and that's when it was done. By doing these things and getting his name and everything introduced and making him answer you like he wants you to answer him, you make that recording self-authenticating, including the one you're making, not just the one he's making. Remember, you don't leave home without a recording device. This includes in your car. I've got multiple ones in mind. Good luck on finding all of them to prevent me from having the record I need.
Nice, Blade. Think of the 22 months. Oh, boy. Here's the actual script.
Now, again, everything you say is directed at one of the three rules. Invoke, demand, protect. Always. Next slide. Question 1. For the record, may I get your name and badge number, please? This is the first thing you ask when the officer approaches your car window. You want to know who it is you're dealing with and how to identify them. Make sure that your recording catches their name and badge number. That makes your recording self-authenticating. Immediately, let's just say, for instance, the officer said his name is Davis and his badge number is 123. Officer Davis, badge ID 123, is there recording being made of this encounter? Again, you want him to tell you whether or not he's making an official record of this. The things highlighted in yellow, while not required, will help you possibly down the line when you start asking the question about, you know, when you ask for this information and they say, well, we didn't make a recording or the equipment was malfunctioning. These three things will help you prove that's a lie if you got an answer to them on your recording. So these are optional, but potentially helpful. Officer Davis, badge number 123, what is the emergency and how can I help you? Again, we're not going to assume we did anything wrong. We're not engaged in transportation. We're not commercial. Therefore, his authority to pull us over for some alleged offense under that code is non-existent. Therefore, we have to ask.
Yes, I forgot to mention that according to these sovereign citizens and these right to travel, they believe that simply the word transportation inherently means commercial activity. So therefore, because it's called the Texas Transportation Code, everything in the code only relates to vehicles engaged in commercial activity. Even though in the Texas Transportation Code, it delineates the difference between a commercial driver's license and a non-commercial driver's license. But that's beside the point. These guys think just simply invoking the word transportation automatically means commerce.
Ask, why are you stopping me? Do you have a problem and do you need me to help you? Because in Texas and most other republics, they can ask for help from the people to subdue a criminal or things of that nature, and you're required to help if you can. So we're going to ask. Officer Davis, badge number 123, what facts or information are you alleging gave you probable cause to stop and accost me? Right there, we're asking the officer to validate his authority. What alleged facts are you relying on as your authority to...
I clocked you with a radar going 55 and a 30. Can I please get your license, registration,
do
insurance?
what you're doing to me right now. Now, of course, he's going to cite immediately something related to transportation. When we get to trial, that's going to...
Well, no. Well, as I said, I clocked you with my radar. You driving 55 miles an hour in a 30-mile-an-hour zone.
Become very important, not only in our defense, but also in our federal lawsuit when we sue everybody in the food chain after this case is over. Officer Davis, back.
Or, yes, Robert, or he could also say, it'll be on the ticket. License, registration, insurance, please.
Badge number 123, do you have a properly signed and issued warrant authorizing you to search me or my property? Again,
I'm not here to search you or your property. I'm here only the only reason I stopped you is for speeding. I have at no point have I ever asked if I can search your vehicle.
again, documenting the right. Do you have a warrant? And
I
this
don't need a
warrant
warrant.
specifically directed at searching, okay? Can you search me or my property? If he says
didn't ask to
yes,
search your-
simply ask to see a copy of the warrant. Texas law is now...
Or let's say, I see an open container, sir. Can you please step out of the car, please? Do you have a warrant to search you? I don't need a written search. I don't need a written warrant. I see an open container, therefore I already have probable cause to search your vehicle. I don't need a warrant to do it.
now written where the officer is not required to have the warrant in his possession. Used to, he had to have it with him. However, even though he doesn't have to have it in his possession, if you demand to see it, he must produce it as soon as is practicable.
Which means you'll get it when you go to jail.
Once he gets you to jail, if the magistrate sends you to jail, once he brings you into the magistrate, which is where he is supposed to take you first and foremost, but never does. Again, if he takes you directly to jail, you've got a lawsuit for false imprisonment that you could go after him with. I recommend
Sure
you
you
do
do.
that.
Sure you do.
Officer Davis, badge number 123, do you have a properly signed and issued warrant of arrest that accurately describes or names me as the person to be arrested?
No, I don't need one for a traffic stop. or to issue you a
Again,
citation.
you're going to arrest me. Where's your warrant? Okay? Your warrant either has to state me by name or description as the person it applies to. Where is it?
Sir, if you do not provide me with your license registration, at this point, the script is already off. Sir, at this point, are you going to provide your license registration insurance? Sir, are you going to provide me with license registration insurance? Sir, is there anything I can do to convince you to provide me with a license registration or insurance? And he's saying this as he's getting the gloves on, and backup has already arrived. Sir, is there anything? And then window smash.
Again, if he has it, has to see it. If he doesn't give it to you right then, he's required by law to still produce it as soon as practicable. For the record, I am not operating in a for-hire capacity by engaging in any form of transportation or other commercial use of the highways. Officer Davis, badge number 123, please acknowledge that you have been so informed.
It doesn't matter whether or not you were in commerce or not. You're required to adhere to the speed limits, the posted speed limits.
Now, this officer's not going to know what you're talking about, and he's not going to care. He may refuse to answer and so on and so forth. However, you want an answer to every question you ask. When they don't answer, do what they do. Keep repeating the question till they respond.
Or they get back up, they get the gloves on, and they smash your vehicle window and drag you out. Who do you think is gonna? What do you think is gonna happen first?
He may say, "I don't care. I don't know. Doesn't matter." But you want an answer to this question before you allow him or yourself to move on. Very important that you get this, because once he admits that you told him you were not operating in transportation, and he continues to do something to you using that as his authority, he has admitted his authority was gone.
According to who? The judge doesn't agree. The judge will never agree. And this is where people find, and that's where most of these idiots who follow this advice find out.
And he held you anyway. That is going to be a very big problem for him in federal court.
Oh, yeah?
I had no authority to keep you there, but...
So the guy... So Eddie Craig, or neither Eddie Craig nor InfoWars posted this video. This is actually from another sovereign... This is from another sovereign citizen from Washington State who uploaded this. But he's like, but he says, your local court will most likely find you guilty as these private businesses masquerading as legitimate courts have a clear conflict of interest.
I did it anyway. Well, we're going to prove to him why that's a very bad idea.
Oh, yeah?
Officer Davis, badge number 123, am I under custodial arrest? Again, this is where he's going to lie.
Well, you are now.
If I am not under custodial arrest, am I free to go?
No, you're being detained right now. And
again, he's going to tell you no. You cannot get the same answer to these two questions. They're completely opposite to each other.
Then what is the fucking difference between detainment and arrest? Does this guy actually believe that if a cop says you're under detainment, you're being detained, that you can still like walk away? Does he actually believe that?
Either you're in a custodial arrest and not free to go, or you're not in a custodial arrest and you are free to go. They can't be the same answer. Officer Davis, badge number 123, what is the articulable probable cause that leads you to believe that I have committed or am about to commit a crime that authorizes you to stop and detain or arrest me? Again, the officer is going to cite some alleged transportation offense as his initial probable cause. You want that in the record. He's already admitted up here that you told him you were not in transportation, and now right here he's saying, but that's still what I'm going to use as my authority to accost you or do anything else to you. For the record, Officer Davis, badge number 123, in order to protect my rights and not waive any by error or accident, I wish to clarify my legal understanding of the situation. You said that I am not free to go, so I must conclude that I am in a custodial arrest and not simply an investigative detention. Therefore, I am invoking all of my fundamentally protected rights, including my right to remain silent and my right to assistance of counsel. From this point forward, I do not consent to providing you with any information or documents that could or will be used against me in a court of law or to possibly incriminate me. So please.
So, again, if you do not... Serrana, why? Serrana is a fucking demon. Serrana is a demon. She's breaking everything. Look at this bad kitty. This is a bad kitty, a misbehaving kitty. You are a menace. You're a bad kitty. You know what you did? You knocked over my America wooden display thing. Could have broke it. Anyway, where are we?
Please do not ask me to produce anything and give it to you. From this point forward, please do not ask me to answer any questions or to perform any tests.
Okay, then, sir, please step out of the vehicle. Pen B
Relating to any matter whatsoever without my attorney present. All right, now the clincher to that setup is going to be this. Officer Davis, badge number 123, do you intend to harm, injure, or punish me by any method of assault, arrest, and or incarceration because I have invoked these fundamentally protected?
No, I'm not doing... No, I'm not. I am forcing you out of the vehicle because you refuse to provide license, registration, insurance, which you're obligated to do under Texas law.
Protected rights. Now that's going to create an immediate problem for the officer.
No, it's not.
Understand this. When you refuse to produce the demanded documents or to answer any questions, the officer is going to begin to get upset and continuously state the following. The law requires that you produce a driver's license and other information on demand of a law enforcement officer. Well, again,
in a traffic stop.
They're also prone to falsely accusing you of obstructing or interfering with a public duty or officer or just outright threatening to commit acts of violence against you and your property. Don't fall for the intimidation tactic. That's what this is.
Don't fall for it, guys. Just they'll relent at some point.
Invoking and refusing to waive your fundamental rights is not and cannot be converted into a crime. And if they do arrest and charge you falsely for interfering or obstructing, then you get to sue everybody. Why?
Everybody!
Because they just punished you for invoking those protected rights. They're doing what they're doing because you invoked the right not to let them. But the moment you waive that right, you won't get it back. And you need to keep that in mind. So just remember, when the officers continue to demand that you produce a license, registration, proof of financial responsibility, or any other information or documents, despite their threats, all you do is keep repeating the following. For the record, Officer Davis, badge number 123, no law is valid if it requires me in any way to waive
Take it up in court.
Any fundamentally protected right in order to exercise any other right or alleged privilege.
Oh, why are you litigating this on the side of the road? I thought you told us earlier that you shouldn't be telling the officer what he should be doing. But now you're trying to litigate this on the side of the road. And also, you're wrong. Take it up in court. Try to fight it in court.
And no law can convert the free exercise of any right into a crime. I have repeatedly informed you that I choose not to waive any of my fundamentally protected rights. So I ask you once again, officer,
yes.
Do you...
Yes, guys, this is why they always say you're going to lose your qualified immunity. I'm going to sue you and your balls as hard as I can in federal court. This is where they're coming from. You think they have a lawsuit because they didn't provide their information.
Intend to harm, injure, steal my property, or otherwise punish me for invoking my fundamentally protected rights. Again, we're putting them between a rock and a hard place on making this choice.
No, they're
because
not.
remember, their video record is showing that all you're doing in a calm, cool, collected voice is invoking your rights.
And the judge is going to see somebody who is refusing to provide his information that he's lawfully required to provide.
The rights that you have that are inherent, they're not constitutional rights, they're not civil rights. They are unalienable, inherent rights. And he can't have them unless you give them away. So don't. If he's going to harm you, he's going to do it anyway. If he's going to threaten you, he's going to do it anyway. Keep that to a minimum whenever possible. But don't waive your rights until you can prove that the only reason you waived them was because of the threat of violence.
No, he's not a lawyer. He claims to be a former deputy sheriff. I don't believe that to be the case at all. I don't know 100% for sure. It's been alleged that that at most he was a part-time corrections officer for a couple of weeks. But I don't know for sure. I honestly doubt he was ever a sheriff's deputy. And he's definitely not a lawyer. The other thing that I was going to say is that in all this bullshit, there's two things that's going on here. In all this BS, this guy is saying this script on the assumption that you're going to win at the court level. No. And as we see it time and time again, you've been watching my channel for, oh my God, like 7 years now. It's never happened. It's never won in court. It's never won at the appellate court, at appellate division either. And any in all of their federal suits are dismissed
Against you or your property. Okay? That's very, very necessary. The courts will give them every possible opportunity to escape if you assist them in any way. So don't. Now, warning. Be prepared for the officer to do or threaten precisely that he is going to harm, injure, or punish you or your property in some form or fashion. So again, they're going to start threatening you with all kinds of things, including the falsified criminal charges we've already discussed. You only need to use this sub-item A portion of this once. Anytime you deal with a particular officer, use it on that officer, and it's only required that you do it once because the record will show that you notified him and gave him the chance and the opportunity. Officer Davis, badge number 123, due to your attitude, demeanor, and your continuous threats to falsify charges and commit acts of violence against me and my property while displaying a deadly weapon, I feel physically threatened and in fear for my life.
I feel threatened.
I demand that you cease and desist and that you get a supervisor here immediately.
Supervisor!
I do not consent to any of your actions, the use of force against me or my property, or to being forced to exit my car for any purpose, especially so that you may attempt to steal my property and or assault, injure, or kill me. Again, we're telling the officer exactly what we expect him to try to do. And it's now a part of the official record. Now it's on his back to make sure that anything he does not give the impression that that is what he's trying to do. This actually sets it up to protect you from the officer's actions by making it known to him exactly what you are expecting those actions to be. And so will any jury that sees or hears this recording. And that, folks, is what we want. We want a record that shows a jury in either court, whether it be at trial or at the federal level when we're suing, doesn't matter. We want to show that we did nothing wrong. We simply invoked our rights. We asked the officer to respect that, and all he could do was threaten us with violence when we did so. That's not going to bode well for him on the other side. Officer Davis, badge number 123, you are fully aware that I have already invoked my fundamentally protected right to remain silent and my right to assistance of counsel. Do you intend to continue in your unlawful efforts to violate my rights?
What?
Just keep repeating.
One gulp. in the chat says, you debated this guy on his radio program years ago? Oh my god, please tell me it's out there in the internet somewhere. Oh man, I would kill to hear. Oh man, I wish that existed. Oh man, I would love to hear that.
Repeating this like a broken record. Once you've invoked these rights, stand on these rights. So, it is my belief that the information you are demanding may possibly be used against me in a court of law.
Actually, Juan, if you want, do you want to come on stream and talk about that? That would actually be pretty awesome.
Or an attempt to incriminate me, and that's true. It will be. And if that is so, then upon the advice of legal counsel, I must respectfully decline to provide you with any information or evidence that possibly can or would be used against me for those purposes. You have the right not to provide it. Don't. Not a hard choice, folks.
All right, 1 second.
Officer Davis, badge number 123. I am asking you again, do you intend to continue to deny me in my rights and to falsely imprison me, or am I free to go? You keep repeating this section down here.
All right, I sent the invite.
And this record is going to be self-authenticating all the way through, and they're going to have a severe problem with anything they do other than just issuing the ticket. That is the purpose. Now, when you start doing this, if they start threatening to break your windows or anything of that nature, you need to know basic safety protection for yourself. Cover your eyes and like this for the side of your face and look down at the center.
Get prepared for the window smash. I like how he warns you about it too. He gives you tips
or anything of that. When you start doing this, if they start threatening to break your windows or anything of that nature, you need to know basic safety protection for yourself. Cover your eyes and like this for the side of your face and look down at the center console of your car so that anything they do won't come flying into your face. But if you do this correctly and you don't lose your temper, the odds of that happening get lower and lower with each passing question. When you are in that car, it is very important that you do not put your face against that 2 to 2.5 inch crack you have on the window. Don't turn and speak directly through it. Don't speak directly into the officer's face. Don't roll your window down any further than the 2 to 2.5 inches. When you talk, you can do it in this manner. Whatever you got to do, tilt your head up, but don't speak directly into the crack or anything else. And here is why. The officer is then going to attempt to escalate this by making false allegations. He's going to say he smelled drugs, he smelled alcohol, anything and everything to give him the grounds to come after you, since he can't do anything more with the transportation stop. You've blocked him at every turn. He wants that DUI or drug bust. That's what he wants. Don't give it to him.
Hello, hello. Yes, but you're very low. Hold on, maybe it's on my end. Say something now.
Something now.
Yeah, you were really low. Is it on? Oh, there it is. Oh, okay. Say something now.
Something now.
All right, much better. Okay, so please tell us about this event.
Oh, geez, I'm thinking it was almost 10 years ago. I heard him on. It was right when I got back on the interweb, and I saw that all the old no driver's license BS was still around, and I listened to one of his videos, and he was talking about his radio program. So I went, and first of all, we went back and forth in the comment section.
Naturally.
And, yeah. And so that evening he was going to have a radio program, and I called in and I told him I was the guy that was going back and forth in his comment section, and so he started his spiel, of course, which I let him talk at great length, of course, and he he seemed to base everything on Lysander Spooner. He seemed to be
Ah.
one of those Spooners because he kept talking about, the Constitution of no authority and that you have to have consent and nobody has consent. And then he got off into the Texas Transportation Code and talking about transportation means commercial and, just
Mm-hmm.
that standard BS.
So, when, so yeah, so for those who don't know, you'll want to go to Juan Galt's YouTube page. Like Lysander Spooner is like he's like the godfather of like the whole voluntarism. You know, consent is literal. Consent of the government is like literal consent, that type of thing. One, hello. I just lost you. I can't hear anything.
Yeah, yeah, no, I
Oh, there you go.
can you
There we
hear.
go. I hear you.
Yeah. No, the thing is that like a, like you were saying that they think consent is what is necessary, and the fact that nobody alive today signed the Constitution, therefore it can't be binding on anyone today because nobody today gave their consent, and that's how they tell in simple terms to their simpletons, and
Mhm.
they buy it.
So when you responded back to Eddie Craig, I assume you refer to Hendrick versus Maryland, the 10th Amendment. Like what was his responses to you?
Oh yeah, I went with all of that, and he just he tried to say that Hendrick was involved in commerce because he had four defenses, and one of them he was saying that it was unconstitutional for states to do that because it would violate uh, interstate commerce, which is the federal government's purview.
Mhm.
So that's where they try to tie in the commerce, but the court only addressed that issue because that was one of Hendrick's defenses, and one of his other defenses was the right to travel, and they shot that down. So yeah, no, he did like most all of them. He double talked real fast, and then
Mhm.
he went back to the Texas Code and his interpretation of the Texas Code.
Yeah. I'm not surprised. Again, most of these guys, and yeah, I've heard the whole, transportation automatically means commerce. I did talk about that before. But and anytime you try to tell them that the code itself delineates the difference between a commercial and non-commercial driver's license, they either gloss over that, hand wave it, or go to some other argument that they have in the bag.
Yeah, one of their favorite ones is well, it's you're talking of motor vehicle, and well, a motor vehicle that's a commercial term. I'm in my automobile, but they don't realize, and then you have to bring them back to Hendrick and said, well, the Hendrick was in his automobile,
Yeah.
and it, and the court throughout that case used the terms automobile and motor vehicle and machine all
Mhm.
interchangeably. So as far as the Supreme Court decides, an automobile is what you say you're driving, and that needs to be licensed and registered.
Yeah. Uh, so last thing on the Eddie Craig, like at some point did you guys like end the discussion amicably, or did he just like cut you off, or what happened?
He cut me off.
Yeah. Well, I mean, I'm not surprised. I kind of wish that we could. I wish it probably. I doubt it exists somewhere, but I kind of wish it did exist somewhere in the internet for us to listen to. but
Yeah,
I thought it was
that
like
was the
years ago.
first call. Yeah, that was one of the first call-ins and live debates I did. So I didn't record it, and I don't think anybody else was recording it, to my knowledge. And
Right.
I haven't seen it posted anywhere since, for sure.
Yeah, that's unfortunate. Well, I'm glad you were able to come on and talk about it. Um, it, it's gonna sound mean, but is Eddie Craig still among the living? I don't even know how old he is by now.
Well, that's a real quinky dink because I'm sure he is, only because in the last 2 weeks I've ran across two people quoting him and talking about him being their guru.
Oh, really? Um, as a matter of fact, I think I have here. Uh, Taylor Spokane versus Port, which I think is a Washington case. Yeah, a Washington appellate case, and Taylor versus Hale. Does he mention him? No. Oh, where was it? But at the very least, this Spokane versus Port, the person explicitly cites to Eddie Craig, by name, in his defense, and the court was like, I don't care whoever the hell that is. You don't even. And I think in one other case, somebody tried to bring Eddie Craig as an expert witness, and the court said no, um, because he never confirmed whether or not he was actually a former sheriff's deputy. So
Yeah, I've heard the same thing you've heard, that he never was really in law enforcement, and the closest he ever got was a jailer, and that was for a short period of time. So yeah, I
yeah,
heard that from source, I think, before I even knew you were around.
yeah. I think, well, the word I'm probably getting it exactly from where you got it. When I first was like getting really heavy into the research about these guys, because this Snoop for Truth character, he's the one who sent me the email, and he's the one who posted a lot of these facts about these gurus like Eddie Craig, Carl Miller, uh, what's the other name? Rod Class, so on and so forth. David Straight. So, but yeah, okay, so yeah, so I appreciate you coming in to talk about it. We're gonna finish this up. I think we're almost done, and then we're gonna go through the frog script, and then close it out. But
Cool, I'll be listening.
all right, thanks, man. I appreciate you coming in. All right, let's finish this up.
Now, what he did was, after they had already written the ticket, they refused to give her back her identification, which was a passport and a student ID. That's what she used for identification. They wouldn't give her her identification back, nor would they give her a copy of the citation, even though she had already signed it. They held her there for another 48 minutes trying to get her to get out of the car by doing the following. What they did was illegal. But if you don't know how to respond immediately to what they do right here, this video is no longer going to be helpful to you in a court of law. It's going to be hurtful. Why? Because the officer has made an allegation regarding a potential offense that you have failed to rebut the moment it was made. A jury sees or hears that, and immediately the presumption of guilt is going to creep into their minds. So you must expect this, you must be prepared for it, and you must respond appropriately. The moment the officer says something of one of these two things here, sir, ma'am, I smell alcohol or marijuana, and I'm going to have to ask you to step out of the vehicle. Or, sir, ma'am, are you aware that you did something, and I'm going to have to ask you to step out of the vehicle?
Oh, hold on. Okay, I do have something on Mr. Craig. As you guys can see here, but I'll blow this up after we're done. Well, you know what? Screw that.
All right.
You already got the gist. Let's look at this. Let's look at this. State seizes business. Owner preparing legal arguments after arrest for outstanding traffic warrants. An outspoken critic of government and advocate of personal liberty was arrested Wednesday, and his Nacogdoches business seized by the state comptroller's office for failure to collect and pay sales tax. 5 Nacogdoches police officers and several law enforcement officers from the comptroller's office arrived at IT Freelancers on North Street Wednesday morning, announcing their intention to halt business there until $33,000 of unpaid taxes are remitted to the state. A local locksmith arrived to change the locks. Eddie Craig, who owns the business, readily acknowledged that he does not collect sales taxes at his business. His store was seized once before in 2005 for the same offense. This is the date of this is March 11th, 2009. David E. Persons, I can confirm that you lived in Nacogdoches. Oh, nice, David. On the tax question, Craig says the comptroller's office violates his 13th Amendment right to be free from slavery and indentured servitude. They are forcing me to operate as an uncompensated tax collector, he said last month. I also informed them that because they removed the lock from the front door forcibly and without my consent, they are now guilty of aggravated burglary and armed robbery. He said by telephone after a brief appearance in municipal court. They sort of just look at you like, yeah, okay, whatever. If you say so, buddy. So that was one link. Where's the second link go to? This is damn it. This is from November 30th, 2008. So this is before the arrest. He's just waiting to be arrested. Local business owner, no former legal training. Craig has studied the law on his own for 15 years, preparing arguments for his case of rebelling against tyranny and injustice beginning earlier this month in municipal court. At 44, Craig has no license but still drives a blue 91 Crown Vic, which has no license plates, no registration, no insurance, and a broken brake light. For these reasons, Nacogdoches police officers issued Craig ordinary citations in December 2007 and again in January of this year, but Craig's case is anything but ordinary. Instead of paying his tickets, about $910 in fines. For the first one, Craig filed a lengthy affidavit in municipal court denying that any crime had been committed and challenging the standing of the court to prosecute him. There and in subsequent filings, all researched and authored on his own, Craig cited legal sources like the Magna Carta, the state constitution of Texas and Arizona, and countless subsections of Texas state law and administrative code. Deacon, think of the $5. Man. Yeah. Okay. Goddess, thank you for the $5. Yusuf L. Yeah, I know Yusuf L has posted Eddie Craig stuff on him. Yeah. Okay. Again, it doesn't say anything in here about his alleged law enforcement history. All right. Let's go to the frog.
We're
So anybody who's asked, why does Artie keep talking about some frog when it comes to sovereign citizens in court doing a script? Well, this is where it comes from. This was uploaded 13 years ago. 322,000 views. God help us. get ready. And again, when you listen to it, it's going to sound like every single, almost every single, court appearance soft sit that you've heard of. Almost.
I'm going to show you how to enforce your right to a fair hearing and to win your ticket in the process. To make this plan work for you, you must listen and speak it out loud to cement it in your brain and tongue so it becomes crystal clear in your own mind and you will be prepared for any response. You must be clear enough that you don't have to stop and think, but must always be in control of this plan. The first appearance you make in court is your arraignment, in which the purpose is for the court to present the charges and find out how you intend to react, by standing up for your rights or being fearful and an easy target. During this proceeding, the judge will inform you of the charges against you and attempt to get you to enter a plea of guilty or not guilty. A third choice is no contest, which is essentially pleading guilty without admitting guilt. Be careful, however, because as soon as you open your mouth to enter a plea, you have given them...
Is the courtroom cold? Why is there like clouds of breath coming out of the frog? Is the courtroom like freezing or something?
...formal jurisdiction over you. If you intend to follow our procedure and win, you must not enter a plea. The judge's first question to you should be something to the effect of, do you understand the charges against you? Or it might be, how do you intend to plea? You must say no, you do not understand, or you cannot enter a plea until you get some questions answered.
Yeah, so your first thing, I cannot enter a plea unless I can get some answers to these questions, Your Honor.
The judge will probably be irritated and try to intimidate you. You must politely state that you need to have some questions answered before you can enter your plea. Tell him that you do not understand the nature and cause of the action against you. Once the judge has agreed to answer your questions, your first question will be, is this going to be a civil action or a criminal action? In the highly unlikely chance that the judge answered your question by saying it is a civil action, your response will be, thank you, Your Honor.
All right, thank you for the 1999 super chat. I'm 21 minutes behind. Please tell me we have this guy's arrest video. RA, unfortunately, we do not. So again, in a lot of states, I know Arizona, at the very least, I know at least Arizona is one. Some traffic, some moving violations are actually civil, but they're like a separate type of civil. New Jersey's kind of the same way, but it's more like they're like they call it quasi criminal, but in Arizona there's like they're considered civil.
Let the record reflect that this is a civil action. Your Honor, since this is a civil action, I make a motion to dismiss for lack of a sworn complaint by an injured party, and no injured party is present.
Denied.
More likely, the judge has stated that this is a criminal action, so you respond, thank you, Your Honor. Let the record of this court then show that this action against me is a criminal action. Now I have another question. Your Honor, the Constitution grants this court two different criminal jurisdictions. One is a criminal jurisdiction.
Remember the guy we listened to? Where he could not get past this point? Yes, Juan. This usually what they're called civil because there's no your liberty's not at stake, that kind of thing. Remember the guy we listened to like last week where you would not get out of this part of the script?
Under the common law, and the other is a criminal jurisdiction under admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution. In which of these two criminal jurisdictions does the court intend to try me? Don't panic if you don't get the article, section, and clause. You'll have them down by the time you have practiced. But if you are afraid of getting it wrong, it would be wise to have some brief notes with that clause number in it.
Oh, yeah?
If the judge gives a specific answer, you will again say, thank you, Your Honor. Let the record of this court then show that this action against me is a criminal action under whichever jurisdiction he replied. However, don't expect an easy answer to that question, as you have just exposed the court's fraud. The truth is that they are acting under a military tribunal of which...
It's just like out of nowhere. Well then. If they cite the state statutes, they're operating under a military tribunal.
They have no right to use with you, but the judge can't say that. And he can't say common law because if he does, you will make a motion to have the case dismissed because there is no sworn complaint by an injured party and no injured party present, exactly like you did if he said it was a civil action. When you protest that there is no injured party, if the judge is silly enough to say that the state of whatever state you're in
That's not silly. Usually that is what the case is. The states usually bring the charge.
is the injured party, then say, Your Honor, I make a motion that this case be dismissed. We are in the wrong court. If the state is a party to the case, they cannot also be the judge and prosecutors.
No, that's incorrect. The prosecutor. Oh my God. You're trying to argue civics with me. Denied.
This case needs to be transferred to federal court or be dismissed.
No.
More likely, the judge will try to avoid answering and will tell you to get a licensed attorney for such legal advice.
Also
Your
true.
response
Get a lawyer.
will be, Thank you, Your Honor, but I don't think you'd be violating your oath of office if you did your duty under the Constitution. You see, I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person without a licensed attorney, and in order
That's fine, but you're not accepting my
to
answers.
intelligently defend myself, I have to know the jurisdiction that this court is
I already told you the jurisdiction. You don't seem to like my answer, so that's why I'm telling you to get an attorney.
operating under, because the rules of criminal procedure under a common law jurisdiction are very
God.
different from the rules of criminal procedure under an admiralty or military tribunal.
Oh
I
God.
need to know under which jurisdiction you intend to try me in order for me to proceed with this case.
I already told you the Texas Transportation Code.
The Sixth Amendment grants me the right to know the jurisdiction being applied, and it grants you the duty to
The Sixth Amendment doesn't say. I don't think the Sixth Amendment says anything about jurisdiction.
inform me, and I don't think you'd be violating your oath of office for doing your duty. Therefore, will you please answer the question so this court is properly identified? If the judge still responds by telling you to get an attorney, your answer will be, Thank you, Your Honor. Let the record of this court then show that I, your name here, the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of the action. Furthermore, let the record also show that this court intends to bring this action against me under a secret jurisdiction known only to licensed attorneys.
It's not only known to licensed attorneys. You can look up the criminal code right now. You can look up the state's constitution right now, where it establishes the authority of the states to conduct to enforce their laws through its own judicial system.
At this point, the judge might claim that this is a statutory jurisdiction
Oh, the nature and cause.
under the statutes of the state of whatever state you're in.
That's
If
what he's
he
talking
does
about.
so,
Okay.
your next statement is, Thank you, Your Honor. Let the record of this court then show that it intends to conduct a criminal action against me under a statutory jurisdiction. But, Your Honor, that raises another question. I have
No, it
never heard
doesn't.
of such a thing as a criminal action under statutory jurisdiction,
Were you educated in school, sir?
and there is no such jurisdiction established in the Constitution.
The 10th Amendment.
I would be happy to accept this, Your Honor, if you could please tell me where I can find the published rules of criminal procedure under a statutory jurisdiction, and where this nature, cause, and jurisdiction information exists.
Texas Criminal Code of Criminal Procedure.
It is imperative that I have the published rules of procedure so that I may conduct a fair defense and a fair trial. Now keep in mind the judge made up this jurisdiction. There is no granted authority for a statutory jurisdiction and no published rules. But don't expect
Okay.
him to tell you that. He must either lie, dismiss a case, or unlawfully enter a plea on your behalf. In rare cases, he might even threaten you with contempt of court. If he threatens contempt, say, Your Honor, I do not wish to be held in contempt.
Well, you're asking for it by asking these stupid ass questions and not accepting my answers.
I am simply trying to exercise my Sixth Amendment right that you disclose the nature and cause of the charges against me. I can provide court citations that show that the exercise of a constitutional right cannot be converted into a crime. Please either identify the properly established jurisdiction, or I make a motion that you dismiss the case against me.
Jessica, thank you for the $9.99.
Also unlikely, but still possible, is that the judge will tell the truth when you ask under which criminal jurisdiction you were being tried, and will tell you that it is an admiralty jurisdiction. If this happens,
No, that's never happening.
you would respond, "Thank you, Your Honor. Let the record of this court then show that this court intends to proceed with a criminal action against me," your name here, "as a condition of contract under an admiralty jurisdiction as a military tribunal under Article 1, Section 8, Clause 17. However, Your Honor, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered into any international contracts, so I deny that any such contract exists. Will you please instruct the prosecuting attorney to inform this court if there is such a contract, and if so, to place it into evidence, and explain how I am party to it and am compelled to perform under it. If the prosecution cannot do so, Your Honor, I make a motion that this case against me be dismissed."
I don't
Of
think with the
course, if
$2.
at any time your case is dismissed, make your pronouncement. "Thank you, Your Honor.
my
Let
God.
the record of this court reflect that case number blah 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 against your name here has been dismissed. Now leave quietly, save your gloating for outside of the courtroom. And if at any time you sense a good opportunity to make a motion for dismissal,
Oh, this. Yeah, okay. Yeah, you're going to be walking out of there. No, you're going to be held in contempt. Or they're going to enter the plea for you and send you on your way.
make it, even if it wasn't part of your prepared script. You need to be flexible and jump on any opportunities that are presented to you. Let's say that the judge has
Nope. Serrana, no. Serrana, wait. Nope.
had enough of your questions and decides to help you out by entering a plea of not guilty on your behalf. Immediately object. Your Honor, I object. For you to enter a plea on my behalf is practicing law from the bench, because entering a
Practicing law from the bench.
plea is my job or my attorney's job. Has the court made a judicial determination that I am not guilty? Now you've really
No. They're required to enter your plea of not guilty on your behalf because under the Constitution, you are presumed innocent until proven guilty. And if you refuse to enter a plea, we're not just going to stand here and say nothing. We're just going to list you as not guilty and call it a day.
trapped him. For him to say yes, he has admitted that you are not guilty. At this point,
No.
state, "Thank you, Your Honor. Let the record of this court reflect that the judge has made a judicial determination that I am not guilty of the charges against me.
Oh my God.
Therefore, I make a motion that this case be dismissed because the judge has determined that I am not guilty." If he says no, he has not made a judicial determination, make a motion that the plea be withdrawn and you be allowed to enter your own plea once you know the nature and cause of the case pending against you. If the judge enters a plea of no contest, object, saying, "Your Honor, I object. For you to enter a plea on my behalf is practicing law from the bench, because entering a plea is my or my attorney's job. I make a motion that the plea be withdrawn. For you to make a judicial determination that I am entering a plea of no contest would result in the court treating me as though I had pled guilty. The court is trying to constrain me to an unfair plea choice in the absence of my understanding the nature and cause of the charges against me." Or let's say that the judge instead gives you a continuance and demands that you obtain a licensed attorney. Ask, has the court made a judicial determination to deny me the right to defend myself in my own person and to force me into hiring a licensed attorney that will conspire with the court to try me under a secret jurisdiction known only to the judge and the licensed attorney?
No.
If you walk out of this hearing without a dismissal, go to Step 2, pretrial
Step
motions
2.
contained in your written packet. You should ask for a motions hearing
And the written packet that you paid anywhere between $50 to $150 to $300 to $500
or
for.
you could ask to have the motions heard at the beginning of the trial. However, to ask for a motions hearing shows the judge that you are not willing to be railroaded so easily. Tell him that you must resolve some pivotal key issues in order to continue and that these motions must be heard prior to a trial. At a
Nope.
motions hearing, you cannot be found guilty, but the case can be
Serrana,
dismissed.
stop attacking the frog.
Either way, when the motions are heard, they must each stand on their own and be heard and ruled separately from the rest. Don't just hand over 5 motions and let the judge say all are overruled. Make him rule on each one individually. Now let's take this from the top in the manner in which it will probably happen. Do you understand the charges against you? No, Your Honor, I don't. I need you to answer a couple of questions. I need to understand the nature and cause of the charges against me. Is this case going to be heard under a civil
Kippa, thank you for the Twitch sub.
jurisdiction or a criminal jurisdiction? Criminal. Thank you, Your Honor. Let the record of this court then show that this action against me is a criminal action. Now I have another question. Your Honor, the Constitution grants this court two different criminal jurisdictions. One is a criminal jurisdiction under the common law, and the other is a criminal jurisdiction under admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution. In which of these two criminal jurisdictions does the court
Oh, this is the practical portion.
intend to try me? If you don't understand the law, you need to hire an attorney. Thank you, Your Honor, but I don't think you'd be violating your oath of office if you did your duty under the Constitution. You see, I am not seeking legal advice. What I want to know is...
And this is what the part where the judge interrupts you from your monologue and tells you, either you enter a plea or I'm going to enter a plea for you.
Intent. I have the right to appear as myself in my own person without a licensed attorney, and in order to intelligently defend myself, I have to know under which jurisdiction that this court is operating, because the rules of criminal procedure under a common law jurisdiction are very different from the rules of criminal procedure under an admiralty or military tribunal. I need to know under which jurisdiction you intend to try me in order for me to proceed with this case.
Do I need to recommend a competency evaluation? Because I don't know where the hell you're getting this idea that we're an admiralty court. We're in Colorado, in Denver. We're the furthest thing away from the ocean.
The Sixth Amendment grants me the right to know the jurisdiction being applied, and it grants you the duty to inform me, and I don't think you'd be violating your oath of office for doing your duty. Therefore, will you please answer the question so this court is properly identified? This is a court under statutory jurisdictions and the laws of the state of whatever state you're in. Thank you, Your Honor. Let the record of this court then show that it intends to conduct a criminal action against me under a statutory jurisdiction. But, Your Honor, that raises another question. I have never heard of such a thing as a criminal action under statutory jurisdiction.
Well, this is why you get an attorney.
And there is no such reference in the Constitution. I would be happy to accept this, Your Honor, if you could please tell me where I can find the published rules of criminal procedure under a statutory jurisdiction, and where this nature, cause, and jurisdiction information exist. It is imperative that I have the published rules of procedure. So,
Liz, I mean, technically, the burden is on the prosecutor to give the prima facie evidence of jurisdiction, which they already have. But as Juan Galda said over and over, establishing jurisdiction in a situation like this, in a traffic case, is stupid easy. It's a given. That's why judges are usually just say it themselves, because like it's so patently obvious that we have jurisdiction to hear traffic cases,
so that I may conduct a fair defense in a fair trial. Look, I'm just going to enter a plea on your behalf and set a trial date. I enter a plea of no contest. Your Honor, I object.
It would never be a plea of no contest. It would be a plea of not guilty.
For you to enter a plea on my behalf is practicing law from the bench, because offering a plea is my or my attorney's job. For you to make a judicial determination that I am entering a plea of no contest
I did not make a judicial determination.
Would result in the court treating me as though I had pled guilty. The court is trying to constrain me to an unfair plea choice in the absence of my understanding the nature and cause of the charges against me. I make a motion that the plea be withdrawn, and this case be dismissed because the court has failed to identify a legitimate jurisdiction.
Denied and denied.
Have a good day, sir. Motion. Your trial date will be such and such a date. Your Honor, I would like to request that we set a motions hearing prior to the trial date, as I must resolve some pivotal key issues in order to continue, and these motions must be heard prior to the trial so that I can properly defend myself.
And that's it. That's where it ends. So even the script already assumes that you're going to fail in getting this thing dismissed at the point of arraignment. So, all right, I'm glad we're done here. Oh no, big and raid. Hey, welcome raiders. You just missed me give a life lesson on or a lesson on the two most used scripts you hear from sovereign citizens, either on the road or in court. So you have to look back and see that one. I was gonna finish here, but I do want to. I'll end it on a humorous note. Because I've always wanted us to cover this deposition hearing. Misconduct. This is the most infamous one. Yeah, this one. So the recap is that the first one was the right to travel script that most of you guys have heard of. It's from an alleged former deputy sheriff, but I think for all intents and purposes, he's not a deputy sheriff. He was never in law enforcement, other than a temporary stint as a corrections officer. Everything that he said, you've all heard it on the side of the road in so many different opposite videos. The next one that you just missed was the Talking Frog a court script. It's the one that most of us have also heard. Usually, I just need to know what jurisdiction we're in. Is this a maritime admiralty or a common law jurisdiction? You know, practicing law from the bench, yada yada yada. All of that came from that video. No, Sean, and I do want to go through. I want to go through that next, but I've only seen this once a long time ago, and I've always wanted to like cover this live, and so this is where we're going to end with to have some humor over the crazy that we listen to. So if you don't know the backstory about this, this is a misconduct deposition hearing. This individual and his firm are being sued, I believe. I'm looking at the description. People v. Robert E. Abrams. Abrams committed several discrete types of misconduct in connection with his corporate representation, defense, and litigation of 3 individuals and a corporate entity. Abrams' continued representation of his clients, the defendants, after he was personally named as a co-defendant in the same action, created a conflict of interest. He did not secure informed written consent from his clients, authorizing him to continue with the representation despite the conflict. So that's where we're at here. In the same case, Abrams filed written discovery responses that violated a trial court order, specifically prohibiting the parties from using ad hominem attacks, sarcastic or bombastic rhetoric, or any language that did not conform to the norms of civil discourse. Further, Abrams repeatedly disrupted his own deposition and prematurely ended the session after less than 30 minutes. The court, which is what we're listening to here, the court-appointed special master then had to review the transcript. Yeah, and this is the deposition.
We are on the record at 9:16. Today is March 12, 2018. This is the video testimony of Robert Abrams, taken in the matter of Justin Markovitz versus Joseph Daniel et al., case number 17 CD 30522 in District Court for the City and County of Denver, Colorado. Today we're located at 110 16th Street, Suite 1400 in Denver. I am the videographer, Timothy Ellermeyer. The co-recorder is Divine Basinger. Will all attorneys please introduce themselves, beginning with the plaintiffs?
Thomas Werge on behalf of plaintiff Justin Moskowitz.
Attorney Robert Abrams, license 37950, appearing pro se.
Neil Sullenberger, attorney registration 48698 for the firm.
Will the court reporter please swear in the deponent?
Sir, I'm going to ask you to raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of law?
I do.
Thank you.
Good morning, Mr. Abrams. As you know, my name's Tom Burge. I'm counsel for plaintiff Justin Moskowitz in this lawsuit. And do you understand why you've been asked to give your deposition today?
No.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
And are you aware that you are a witness regarding the actions of Abrams and Associates?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I
don't
don't recall.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I've answered that question. Object to form. Move on.
Mr. Abrams.
So, first things first, you're a defendant in this case who's being deposed. You don't get to object. Your attorney gets to object.
Have you been deposed
Object to
before?
form.
Object to form. Move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master.
We are going off the record.
No, we're staying on the record, please.
Okay.
I have been deposed, Juan. I'm not going to elaborate on that, but I have been deposed. I've never been a witness at trial, however.
Would you be prepared to read back my answer to the special master regarding counsel's questions as to whether or not I answered that question?
Good
Bring it in.
morning.
Thank you for the
Could we
51 months.
speak with David Tenner, please?
Let me check and see if he's good. May I ask who's calling?
Thank you. Yes, these are the parties from the Moskowitz versus Dahlman matter, and we are in the middle of a deposition this morning.
Okay, hold on just a moment.
Thank you.
He is not in the office at the moment. Can I get a number and have him call you back?
Yes, that would be great. If you could please.
Okay, I'll send him an email right now.
Appreciate it.
You're welcome.
Bye-bye.
So a special master is generally another attorney, a third party disinterested attorney who acts as a mediator. And when it comes to depositions, yeah.
We
Mr.
stay on the
Abrams.
record here.
Yeah, we're still on the record.
Okay.
Yeah. Mr. Abrams, I want to ask you one more time. Have you had your deposition taken before?
Object to form.
Asked and answered. Move on.
You need to answer the question.
The question was answered. Excuse me. Have her read it back.
Yep.
Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not harassing
We're
you.
going to move for sanctions
I'm
against
asking you to
If you're not
answer
going
the
to
questions.
allow
He just
her-
answered the question.
He did not answer the question.
He just said he did not recall. That's an answer to the question.
So it's your testimony under oath today, Mr. Abrams, that you do not recall whether or not you've ever been deposed before.
Asked and answered. And so please read
You
my
need
answer
to
back.
answer my questions, Mr. Abrams.
No. He has an attorney. The guy you're hearing on the right side, that's his attorney. But he's objecting himself, which you can't do.
Please read the answer back.
No, do not read the answer back, Mr.
Like-
Abrams.
like the
This
answer
is-
to be read
Let's
back.
move on. How many times have you been named in a lawsuit in your individual capacity?
I can't recall.
Have you ever been named in a lawsuit in your individual capacity?
I think so.
Okay. And when do you think that you were added as a defendant to a lawsuit in your individual capacity?
It may have been, if I get it right, it may have been in the BB matter.
So it's your testimony today you've been added, you were a defendant in a lawsuit in one matter, and that was the BB matter, is that
Objective
correct?
form.
I think they added me as an individual defendant, and they lost the case that went to jury trial. I think that's my recollection. I don't remember it very well. The man, BB, attacked me in a stairwell and at my garage, and I think he named me individually in that suit, and then he lost that suit. That's my recollection.
Let me ask the question again, Mr. Abrams. Is this BB matter that you're referring to the only time you remember being added as a defendant in a lawsuit?
Objective form.
To my recollection, yes, that's my answer.
And you said the other party was named BB?
Yes.
Okay. Could you, what was the other party's full name?
Sean Beeson. We call him BB. I represented him in a matter where him and his wife were both arrested for DUI. He was thrown in a drunk tank for being belligerent, and he sued the city. And then I put a restraining order on him for 9 months for attacking me in a stairwell. And then he sued, I can't remember if he sued me individually, but I think he did. And then he lost that suit outright at jury verdict. So we're gonna move to strike that as irrelevant, object to form, and that it's gonna lead to non-discoverable evidence. Under the rules of evidence.
Mr. Abrams, you are
Excuse me,
not
you can't
allowed
interrupt me.
to. I am allowed to
He's-
interrupt you. This is my
he's
deposition
giving his
today,
answer.
sir.
You can't- it's
And
my
you
answer.
need- it
This
is
is my
not.
answer.
You are not allowed to put objections on the record. You are a witness today. And Mr. Abrams, you are represented by counsel. Your counsel is allowed to put objections on the record. You are not today.
I am a lawyer.
Do you understand that?
I am a lawyer. I don't need a lecture from you who doesn't understand the rules of evidence. Under the rules of evidence, the only thing that can come in under the rules of evidence is truthfulness and untruthfulness. So to the extent that you're trying to disparage me because you have me on videotape and embarrass me for things that you can't bring in, I'm going to raise, move to strike, find it objectionable,
And move to
then
sanctions.
move for sanctions for harassment under Rule 30D. You can look it up if you don't know it.
Mr. Abrams, I feel quite confident that if any sanctions are entered in this matter, it's going to be against you.
Objective form.
For
Objection.
continuing to obstruct and not answer any of my questions.
Objective form.
Objective
You
form.
cannot
I
object.
just did.
You cannot.
I just did.
I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished.
Oh yeah.
If you laugh at me one more time, we're going to walk out.
We're going to move for 30D3
We're
sections.
going to move for harassment sanctions against you right now. Okay, you're laughing at us with the videotape that you published on the internet about you and your rock band, and you're going to be laughing at me. And you've moved for sanctions and had them denied every single time in this matter, and the jury should see that too. Every single one has led to no sanction,
Mr. Abrams, are
including
you
the last
aware?
one where we quashed all of your subpoenas. And you asked for attorney's fees and you got no sanction.
Mr. Abrams,
Let's move on. Do you have a question for me? You sued my firm.
Oh, boy, here we go.
belligerently under the abuse of your law license, where we counter-sued you. We have a counterclaim against you for abuse of process for misusing your law license. You sued me for fraud, civil conspiracy. I mean, not civil conspiracy. Conspiracy, which is a criminal act, so you did that wrong, and aiding and abetting, which is a criminal act, so you did that wrong. Ask me questions about that, or I'm leaving.
Mr. Abrams, we're going to be here for a long time today if you do not answer my questions.
Objective form.
I just want to let you know that right now
Objective form.
and put that on the record. Mr. Sonberger, I'm sorry. Stop laughing at
Yeah,
this is
this is-
bizarre.
Stop laughing at my
Bizarre.
lawyer and stop harassing us.
Listen,
You
let's
brought us down here for fraud. Ask us fraud questions.
Stop laughing at me!
Mr. Abrams, how many times has your firm been added as a defendant in any lawsuit?
As I can recall, one in the BB matter.
So the BB matter and then this matter as well? Those are the only 2 times you recall that your firm has been added as a defendant?
Yes, as I recall.
Aside from traffic tickets, have you ever been named in a criminal action?
Objective form.
Objective form and privilege, so I
And-
assert privilege and need not answer.
What privilege are you asserting, sir?
Attorney-client privilege and
It's attorney-client privilege to state. Okay.
we would.
I mean, I don't know if he has to answer that question, but I don't think that's invoking. I don't think you do that by invoking privilege. I don't think any attorney-client privilege has anything to do with the question that's being asked. I don't think he has to answer the question, but
Under the law, I need not answer that.
What law are you referring to, Mr. Abrams?
I need a law book. It's. And I move to strike, and I move for.
Move for sanctions.
I move to strike the question. I refuse to answer under privilege, and I move for a protective order on the question. So certify the question and move on.
You've again not answered my questions. You've made a absolutely baseless assertion of privilege. Are you aware that in a deposition, the proper objections that your lawyer are allowed to make are as to form and as to foundation? If there is a matter that's privileged and your lawyer objects to it on the basis of privilege, he can instruct you not to answer. Otherwise, you need to answer all of the questions that I give to you today. Do you understand that, Mr. Abrams?
He's raising an objection to privilege.
There's a pending question. Could you please read it back?
What law are you referring to, Mr. Abrams? We can go back.
Oh my God! There's a stenographer in the middle of this. Oh no! Imagine being her. Oh no!
Aside from traffic tickets, have you ever been named in a criminal action?
So objection, privilege. Move on.
You are not answering the question today. You're refusing
Object to
to
form,
answer it,
object
Mr.
to
Abrams.
privilege.
Move on.
Move on.
It's the answer. Objection, privilege. Move on.
What privilege are you asserting today, Mr. Sullenberg?
Attorney-client privilege. He's already answered the question.
So Mr. Abrams is saying he has an attorney-client privilege over himself being named as a criminal defendant.
Yes.
And the question's intended to harass.
No! No! Oh my God! No! Just no. At best, you'd be invoking your Sixth Amendment right to self-incrimination. But even then, he's just asking if he's ever been criminally charged before.
And annoy. And under 30D3, again, we're going to move for sanctions for repeated conduct like this.
I can't even get through my initial questions here because you are being so obstructionist.
Did I say 6? I meant to say 5th.
That's because you're a weak lawyer, but go ahead. You sued me for fraud. Ask me fraud questions. You sued my firm for fraud, aiding and abetting, and conspiracy. You have no evidence. Put something in front of me and we'll answer the questions. You have nothing. You have nothing.
Mr.
Put
Abrams,
something in
are
front
you
of me.
aware that Judge Starrs already ruled that there is substantial evidence against your firm that you committed fraud?
Object to
for misrepresentation,
Object to
mischaracterization. The fact that the judge let you bring your bogus claim against us doesn't mean that it's merit full. Do you have a fraud question for me?
Please answer the question.
He just did. Ask
I
and
did.
answer.
Are you
We're
aware?
Yes, I'm aware. Move on.
Mr. Abrams, have you ever
Yes.
been arrested?
Object to form and privilege, attorney-client.
That's it.
And you're instructing your client not to answer that question on the basis of attorney-client privilege, Mr. Sullenberger.
It's my understanding that Mr. Abrams had an attorney for any issues that may have arisen, and therefore he can assert.
I also don't recall being arrested.
What part of my question asked for any attorney-client privilege?
He's not being
communications?
deposed.
I don't have to. I objected. I
We're not
objected to
asking
form.
questions.
I objected for privilege for Mr. Abrams.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions
clear that
today,
you're harassing
and
us.
you are refusing to
Object
answer
to
any
form.
questions
Every
today.
question, read every question back.
Yeah, you
Object to
have
form.
not.
We
Move for
disagree.
sanctions.
Okay, let's ask a couple more questions. Mr. Abrams, what are the pills that you just took?
Object to form.
None of your business.
Yes. Oh, here we go. Here we go.
None of
Privilege.
What are those other pills?
Object to form.
None of your business.
Object to privilege.
None of your business.
Medical privilege. Don't
Mr.
have-
Abrams, are you under any any drugs today? Have you taken any drugs before you came to this deposition today?
No.
Okay. Have you taken any alcohol before you came to this deposition today?
No.
Any medication whatsoever?
No.
Wait, why? Why is he directly answering these questions?
No. Just
Now I feel like now I feel suspicious as to why he's directly answering these questions, but not the other one.
these pills that you're taking here.
Yes.
That you are refusing to answer what they are.
Yes.
Medical
None of your
privilege.
business.
Okay.
But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
My God.
Oh, you're referring to when you called me fat when you walked in here.
Object to
I don't recall
form.
that.
You don't recall that? Okay. Well, we have a couple witnesses to that, including Mr. Sullenberger. In any event,
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
Mr. Abrams, do you recall the motion to quash the subpoena for your testimony
Yes.
that you filed? And you attempted to quash the subpoena to disallow your deposition to be taken, correct?
Object to form.
I don't recall that. I remember we successfully quashed your bad faith depositions. You moved for attorney's fees and you were denied by the special master. That's my recollection, that he found them, that he found them when we told you I would be out of town to, in bad faith, then schedule the deposition to pull me out of my vacation. He found that to be objectionable and he commended me on taking a vacation under the stresses of this profession. So I remember the special master commending me and quashing you. That's my recollection.
Are you here today pursuant to the subpoena?
Yes.
Okay. So your subpoena didn't get quashed, did it?
Yes, it did.
Sure didn't.
Yes, it did. Argumentative. Move on.
Then why are you?
What are you laughing at? Why do you keep laughing? What is it with you? Why don't you look at the camera and laugh at them?
Mr. Abrams,
Your
testimony is being taken
Just
today.
ask me some questions about fraud, civil conspiracy, and what other trumped up things you did under your license that we're moving for sanctions against you. Do you realize we sued you for abuse of your law license? Do you realize that? And that we're going to continue to sue you for the way that you've been treating in this matter? You have no evidence. If you do, show the jury, put it in front of us, we'll ask questions. You haven't put one document in front of us. Open something up and make this a meaningful deposition or let me go.
Is there anything else you'd like to say, Mr. Abrams?
Depends on what your next question is.
In the motion that you filed to quash the subpoena, isn't it true that you admitted to the special master that you were in fact in town?
Object to form.
Uh-oh.
We told the special master in a pleading that I returned at home at 3:30 in the morning on the same day that you scheduled my deposition, and that there was no way I was going to be able to come to the deposition with no sleep. We filed
So
your
you were in
conduct
town at the
offensive.
time, you were in town on the time that you were scheduled to be deposed, but you
Object to
nevertheless moved to
form.
Asked and
quash.
answered. Move on.
Mr. Abrams, are you refusing to answer?
I answered
Object
the
to
question.
form.
Move on.
You don't get to not answer when you object.
Object to form.
Do you understand?
I answered the question, and I even told you what time I returned on the day. What more? Why are you harassing me?
Mr. Abrams,
Stop harassing
listen
me.
to my questions.
harassing
Today,
me.
that your job is to listen to my questions and answer your questions under oath. Do you understand?
Objection
Object to form.
asked and answered. Move on.
I'm waiting for your answer, Mr. Abrams.
Her first question was the same question you asked. If we need to go back to the very beginning to ask whether I said I would be here under oath, we can go back and ask the court reporter.
Mr. Abrams, in that motion, you included that Mr. Abrams' anxiety requires him to take medication on extended flights that impairs Mr. Abrams' facilities. Can you please explain what medication you were referring to in your filing?
Object to form
No.
medical privilege.
Privilege.
Medical privilege.
Yes. Move on.
What privilege is that?
None of your
Absolutely
business.
no right.
No, what medicine I take is none of your business. Move on.
You filed a motion with the special master saying that because of a certain medication that
Yep.
you could not sit for your deposition.
Yes, that medicine's none of your business. Move on.
And now
Objection,
you've
privilege.
come into this deposition today with a handful of pills
Yep.
that you refuse to answer questions about
Yes,
what they are.
None of your business. HIPAA protection privilege. Move on.
But if you're using the medication as the basis for what this is, quashing the subpoena or objecting to a deposition, if you're using the medication as a basis for it, I don't know if you could just say I don't have to answer what the medication was. I think it would be relevant, wouldn't it be? I mean, I don't know the full things about HIPAA, but I don't think HIPAA protects you in that case.
We are going to continue this deposition now, Mr. Abrams. You have made it clear you are not willing to answer any of the questions today. You have been objecting. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And will represent your conduct during this deposition as well.
Please do.
For the record, since the moment we've walked in here, I and my counsel have answered every single question and rightfully asserted 30D, I think it's
30D3.
for harassment. We've answered every single question. We've asserted privilege where counsel refused to accept privilege. And we've been nothing but harassed under 30D3. We're moving for sanctions. We're moving to quash the deposition for future. And we're here to answer all of the questions regarding why my law firm was surreptitiously brought into this lawsuit for fraud, conspiracy, and aiding. And he hasn't asked one question in furtherance thereof.
We will
Until he
continue
does,
all three of the
we will
depositions
move
that
to
are scheduled
strike.
for today because it is very clear that Mr. Abrams, Mr. Sullenberger, and their firm intend to obstruct discovery in this matter and do not intend to answer the questions today. We will ask that it be reconvened before the special master with Abrams and Associates to pay the full amounts of everything associated with the depositions, including the special master's fee. And we will be filing a motion to take that up with the special master today.
We disagree. We're filing the exact same motion and seeking the exact same sanctions. Anything else?
We will continue the deposition and go off the record at this time.
We're going off the record at 9.
Okay. All right. This is talking about the description of the deposition. Further, Abrams repeatedly disrupted his own deposition and prematurely ended the session after less than 30 minutes. The court-appointed special master then had to review the transcript, issue an order sanctioning Abrams, and personally preside over Abrams' second deposition. During lunch break on the second day of trial, Abrams went to opposing counsel's office building with no legitimate reasons for being in the building at that time. He rode the elevator with opposing counsel and his client, the plaintiff in the case, over objections from opposing counsel and a security guard. Abrams was disruptive to and confrontational with the people in opposing counsel's office. Based on this conduct, the trial court entered a restraining order against Abrams, listing opposing counsel as the protected party. Finally, Abrams recklessly and falsely submitted to the court an affidavit that contained inaccurate information. Through this conduct, Abrams violated Colorado RPC 1.782, A lawyer shall not represent a client if the representation will materially be limited by a lawyer's responsibilities to another client or by the lawyer's personal interest. Colorado RPC 3.4C, a lawyer shall not knowingly disobey an obligation under the rules of a tribunal. RPC 8.4C, providing that it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, and misrepresentation. And RPC 8.4D, providing that it is a professional misconduct for a lawyer to engage in conduct prejudicial to the administrative justice. Here's what he got. The presiding disciplinary judge approved the party's amended conditional admission of misconduct and suspended Robert E. Abrams for 1 year, 90 days to be served, and 9 months to be stayed upon the successful completion of a 2-year probation. The suspension took effect on May 14, 2020. The date of the deposition was back in March 12, 2018. Abrams was the one being questioned. So, all right. At least we ended on a hilarious note. Okay, I thought that was funny. All right, I appreciate you guys coming in. I hope you guys learned something. Hit that like button before you head out. Oh my god, I gotta clean up the mess. The kids made here next to me, and I might not be streaming tomorrow, but I will definitely be streaming on Wednesday for sure. But hit that like button, join my Discord. Thank you all for the tips. Much appreciated. And motion for merch, a coffee mug that says don't take legal advice from frogs. You know, that's a good, actually, Kat, that's a good idea. I'm gonna write that down. Make a sticky note. Coffee mug idea. Don't take legal advice from virtual frogs on the internet. I'll work with that one. All right. Take care. Have a good one. And I'll see you next time. Bye-bye. Thanks, Kat.